Hello and welcome back to the MOOC Oral History. Today we will be discussing the topic of the unit is ownership and rights management. Oral History project pose complex question of authorship and intellectual property. An oral history interview is a collaborative creation involving at least two parties, the interviewer and the narrators, and often an institution. Legally and ethically, questions arise about who owns the resulting interview, including audio, video, recordings, transcripts, and supporting materials, and what rights each party holds. Generally, the narrator's spoken words, once recorded or transcribed, constitute an original creative expression, a literary work under copyright law, while the interviewer's contributions, questions, editing, and direction also create protectable content. Moreover, the sounds video recording itself is a separate copyrightable work. In most jurisdictions, including India, the narrator initially hold copyright in their own narrative, and the interviewer or producing organizations hold copyright in their recording and any editorial contributions. In practice, institutions commonly require signed agreements, release or gift form to clarify these rights at the outset. Narrator versus interviewer authorship. Under Indian or international law, when a narrator's speech is fixed, example on tape or transcript, it qualifies as an original literary work with the narrator as its author. The interviewer who formulates questions and may edit or structure the interview likewise holds copyright in the part they create. Thus, an oral history often has joint or multiple authorship. The narrator owns copyright in their spoken content, and the interviewer or their employer owns copyright in the interview's words and in the recording they make. The 2016 Archives Ethics and the Law in India guidebook illustrates this scenario. Copyright in the spoken word of the participant or interviewee would normally vest with the participant as an original literary work. Once it has been fixed in some material form like a transcription or a tape. Similarly, the authorship of the interviewer's word will vest with the interviewers themselves, and ownership may vest with the interviewer or their employer according to the context. Likewise, the sound recording embodies separate rights, a separate copyright in the sound recording of the particular spoken words of the participant. The ownership of copyright in the sound recording will vest with the producer or person who make the sound recording, normally the interviewer themselves or their employer. These principles align with common practice in oral history. US oral historians note that as soon as the interview is recorded, the oral history narrator initially holds the copyright, but standard practice is to prepare a consent form to transfer away those rights. The Oral History Association similarly assumed that interviewers will secure release in which narrators assign or license right. The interviewer should secure a release form by which the narrator transfers his or her rights to the interview to the repository or designated body. In India, the Copyright Act of 1957 recognizes similar concepts. Spoken testimony fixed in recording is an original literary work, and the person fixing the recording is treated as its producer. with corresponding right under section 38, the performer's right. These performer rights allow the narrator as a performer to control productions or public communication of their performance. In practice, however, oral history collectors often clarify ownership by agreement, joint and collaborative works. Because both narrator and interviewer contribute creativity, many interviews are legally joint works or collaborative works. The Oral History Association glossary defines copyright in this context when two or more authors combine inseparable part as of occurs in an interview, the work is considered joint work and its authors are considered joint copyright owners. In oral history, co-copyright can include narrators, interviewers, and organizations or institutions. In other words, all collaborators hold equal rights unless an agreement says otherwise. This concept is echoed in legal guides. Archives are advised that an interviewer's recording, quote unquote, produced with the narrative may be a joint or derivative work, implying shared rights, where the interviewers or a funding institution is an employer. The copyright might automatically vest in the employer by work for hire rules, again depending on local law. Copyright assignment and licensing. Given these multiple interests, oral history projects typically use written agreement to specify ownership and uses. Common practice, especially under traditional models, has been to assign copyright in the interview both narrators and recordings rights to the archival repository or interviewer. For example, as one historian recounts his consent form granted him any title to copyright or property right or literary rights in the recording and transcript. Likewise, repositories often ask the owner to sign a deed of gift or release formally transferring rights. The Oral History Association glossary notes that deeds of gift convey material without compensation, and release form can assign or license intellectual property. Many US oral history programs have followed this path, requiring narrators to sign over their rights so the archive can preserve and publish the material. However, consent practice vary, especially with digital dissemination. Some projects now explore alternative models. For instance, the Cities, Suburb and Schools project at Trinity College pioneered a Creative Commons consent form under their CC by NC Creative Commons Attribution Non-Commercial license. Narrators retain full copyright but granted the project rights to share their material non-commercially. As the project team noted this, we prefer the Creative Commons consent form because it clearly keeps the copyright in the hand of the oral history interview participant, but allows the archive to freely share the recording and transcript on our open access public history book and library repository, where individuals and organizations may copy and circulate it as long as they credit the original source and do not charge any fees. This non-commercial restriction assure participants that other people. In one case, an interviewee even negotiated a non-derivatives clause to ensure his or her story could not be excerpted or out of context. Such practices illustrate a trend towards license ownership. Narrators may donate their interviews but specify terms using CC or custom language under which others may use the material. Indian law and international standards. Indian copyright law generally follows Berne Convention standards. Uh, in bracket, India is a Berne signatory. Any original literary work, including an oral narrative fixed in writing or recording, is protected automatically. The Copyright Act provides that copyright subsists from creation without formalities. Terms of copyright vary by category. Literary work, the narrator's word, are protected for 60 years after the author's death, while sound recordings, the interviewer's recording, are protected for 60 years from publication. The Act also recognizes moral rights. Even if copyright is assigned away, the author retains the right to claim authorship and to object to any distortion, mutilation, or other modification of the work prejudicial to their honor or reputation. Thus, an interviewee in India could insist on credit as author and could challenge an abusive edit of their testimony. Similarly, moral right concept exists internationally via the Berne Convention Article 6b. Consent remained critical under all frameworks. Oral historian must obtain informed consent to document how narrators want their interviews used. In India, while there is no specific oral history statute, generally privacy and contract principles apply. An unwritten interview has unclear rights until a contract is made. Archival guidelines therefore emphasize signed consent form specifying IP assignments and uses permission. For example, the Indian Memory Project, an online archive of citizen contributed family stories, explicitly states that it does not own any copyright to submitted images or narratives. Contributors retain ownership but agree to grant the project free publication rights and a percentage fee if third parties later license an image. Once published on the site, submissions will not be restricted, giving users confidence in their permanency of their archive. This model contrasts with repositories that claim broader right. The 1947 Partition Archive, for instance, requires contribution to grant the archive a perpetual royalty-free license to reproduce and distribute their submitted stories. Such variations underscore that ownership in oral history is ultimately determined by the contracts parties sign with the bone of law. In summary, ownership of an oral history interview is multifaceted. Indian law and international practice recognize at minimum the narrator's copyright in the spoken content, interviewers or employers copyright in their contributions and recording, and often treat the combined produce as a joint work. Clear release agreements are therefore essential. Oral historian must explain these issues to narrators, ensuring they understand what rights they are keeping or giving up. Ethically, guidelines such as the Oral History Associations stress that informed consent must be transparent and the narrators are fully apprised of how their interviews may be used. Creative Commons and the other license offer one way to balance sharing and narrator's control. But in any case, the archives policy must align with the wishes of its collaborators and with law, archival ethics, and institutional liabilities. Beyond formal ownership, archives and interviewers bear ethical and legal responsibility in handling oral histories. This includes safeguarding narrator privacy, managing access appropriately, and protecting the collection and participant from legal harm. Whether in India or abroad, professional best practices emphasize informed consent, confidentiality, and respect for the narrator's agency throughout the process. Informed consent and narrator autonomy. A foundational principle is that oral historians must ensure narrators consent freely and knowingly. Prior to the interview, the interviewer should explain the project's goal, potential risk, and possible future uses of the recording. The Oral History Association outlines this clearly. Interviewer obtain the narrator's informed consent, documented in writing or orally, and communicate the project aims and uses of the interview. Narrators must understand that once an interview is made accessible, for example, online or in public archive, it could be used in multiple ways by researchers, educators, or the media. They should know they can pause, refuse to answer, or even terminate the interview at any time. Importantly, narrator must have final say on releasing the interview. The recording should not be published until they have reviewed it and formally authorized its public use. This narrator review step is a hallmark of ethical oral history. It distinguishes oral history from other research methods by giving narrators control over their own narratives. Archivists often build in producers for the review, including draft transcription or summaries for approval. Consent forms and release agreements are key tools. These documents typically spell out how intellectual property is handled, as discussed above, and also cover confidentiality, anonymity, and uses restriction. For example, many archives allow narrators to choose an embargo period, withholding public access until a future date, or to anonymize sensitive details. The 1947 Participant Archives explicitly offers survivors a partition choice after the interview. Contributors choose to what extent and on what media they want to share their interview. Library only, website, YouTube, etc. and may remain anonymous or delay the release of their interview. The archive underscores that interviewees' preferences are of utmost importance to us. In practice, such informed consent practices mean no one is surprised by how their story is used, a critical safeguard preserving trust, privacy, and access control. Oral historian must be vigilant about personal data. Interviews often touch on intimate detail, family matter, traumas, political opinion. Although narrators share willingly, archives have a duty to protect privacy as much as possible. True anonymity is hard to guarantee, but archives can restrict access where needed. Many archival codes permit closed records. For instance, any archive may mark a recording as inaccessible to researchers for a set of period. However, even closed archive must obey legal orders. They remain subject to subpoenas. In other words, confidentiality is treated ethically but has no absolute legal privilege. Ethical guidelines recommend minimizing unnecessary identification and allowing confidentiality arrangements. The Oral History Association advised the interviews by describing and cataloging ways that respect the narrator's desired privacy and wants historians to be aware of libel and privacy laws. Interviewers argued to handle sensitive content carefully. For example, if a narrator reveals defamatory or incriminating information about others, the interviewer or archivists must consider whether to redact names or restrict access. In India, although there is no specific oral history statute, generally privacy protection now recognized as a fundamental right and defamation law apply. Archives in India must therefore be cautious. Disclosing personal data without consent could implicate privacy rights, and publishing false statements about third parties could lead to libel suits. As the Oral History Association notes, oral historians should educate themselves about legal concerns such as libel, invasion of privacy, and other issues that might endanger their narrator. Institutions often adopt specific policies for access. Some choose a default embargo, example 10 to 30 years, unless earlier release is approved. Others negotiate case by case with narrators. Closed or embargoed interviews are typically listed in archives findings, aids, but withheld until conditions are met. Even then, interviewers should consult contributors before broad release. Example, when new technologies emerge, online streaming or transcription, archives may contact participants or heirs to confirm consent as recommended by professional ethics. Without clear permission, archival managers risk alienation narrators or communities. Institutional liabilities and safeguards. Archives and the researchers face potential legal liabilities if they mishandle oral histories. Three prominent areas of risk are subpoena and legal compulsion. In many jurisdictions, there is no special privilege protecting oral history content. Courts can subpoena recordings or transcripts just as they can any other document. Ethically, archivists may try to negotiate, example, by anonymizing the data or explaining the context, but they ultimately must comply with valid legal orders. The Oral History Association glossary bluntly states that even closed record still be provided record in response to a subpoena. Archives should therefore secure informed release that anticipate such scenarios and consider safeguards like encrypting sensitive data in advance. Defamation and liability. If an interview contains a defamatory remark about identifiable individual, the archive or interviewer could potentially be sued as publishers. In India, defamation, both civil and criminal, remain as a serious legal issue. Archives should have protocols for reviewing content, perhaps with legal counsel, before widespread dissemination. Often, this is handled by giving contributors the right to review transcripts. If problems arise, interviewers may redact it or, in extreme cases, withheld entirely. While specific cases law on oral history defamation is scarce, caution is warranted. The Oral History Association ethic of narrator review and the liability to keep interviews offline helps mitigate this risk. In practice, libraries resolve most disputes through administrative means. Example, correcting errors or restrict access. But archives should be prepared to comply with any court orders to remove or modify content. Privacy breaches. If any archive unwittingly exposes confidential personal information, example, medical details, addresses, it could face legal or reputational consequences. In India, data protection law is evolving, but in any event, commonly law and human rights principles demand careful treatment of personal data. Archives minimize this risk by de-identifying sensitive data, storing interview records securely, and honoring confidentiality agreements. For instance, interviewers often avoid including unnecessary biographical details unless relevant or use quotes, pseudonyms in transcripts. Institutional guidelines typically require robust data management, lockable records, limited access to raw interviews, and clarity on which metadata, birth date, address, etc. can be shared publicly. Access policies, and public availability. Archives balance the narrator's wishes with the public interest in historical knowledge. Oral histories often carry high research value, so the trend is toward sharing while respecting restrictions. The Oral History Association explicitly encourages equitable access. Once interviews are finalized, recommend documenting each interview's conditions in the metadata, where permissible archives publish interviews online or in catalogs, often with transcript or summarized for searchability. Narrators can still impose conditions. They might, for example, request that only their first name appear in credits, or that only researchers rather than the general public may view the interview. Some projects adopt tiered access. Immediate family might get full access. Academic researchers get redacted transcripts and the public gets summary access, etc. Comparative practices, India and global. Internationally, oral history ethics are codified by bodies like the American Oral History Association and National Archives. Their guidelines emphasize narrator-centered practice. Interviewers and archives must treat narrators with respect, ensure transparency, and protect personal rights. In India, there is no a single oral history authority, but national institutions have begun formal programs. For example, the National Archives of India and various state archives have launched oral history projects on partition, freedom movement, and local histories. These projects generally issue call for interview forms that include release language reflecting both government and international standards. The Indian Council of Historical Research advises researchers to obtain informed consent and maintain a copy of the interview for the narrator. However, archival ethics in India are still evolving and may practice norms come from anthropological or museum contexts. Example, the FAIR principles for indigenous cultural heritage. By contrast, the 1947 Partition Archive exemplifies current best practice. It provides intensive interviewer training, use multiple consent forms, and allows interviewees to specify exactly how and when their stories are published. Its citizen historian approach even invite narrators to submit and approve their own stories. Grassroots initiatives like the Indian Memory Project similarly center contributors' control. As seen, the project does not claim any IP in submission and provides clear terms on uses. In summary, whether in India or abroad, responsible archives respect local norms such as individual privacy right while striving for openness. Ownership and rights in oral history are not fixed by some unique law but emerge from a confluence of copyright principles, contractual agreement, and ethical norms. The narrator has inalienable interest as a author of their story and performer of their interview, while the interviewer or institution hold interest in the recording and curation. Good practice demand clarity. Narrators should be told who will hold what rights, how their story will be used, and what controls they retain. In India, the Copyright Act provides the basic legal framework, treating oral narrative as literary works and recording as sound recordings. And international conventions like Berne underpin moral rights and authorship concepts. Ethical archives go further by involving narrators in all phases, from consent to metadata, and by establishing policies, embargoes, license review that honor narrator preferences. Legal safeguards, carefully released forms, secure storage and legal review of content, help mitigate liability for defamation or privacy breaches. Ultimately, oral history thrives on trust and reciprocity. When interviewers and archives handle ownership and write thoughtfully, for example, sharing credit, granting reasonable public access, and protecting sensitive information, they uphold both the letter of the law and the spirit of community memory. Narrators who know their rights are respected are more likely to share openly, enriching the historical record. By blending precise legal stewardship with clear and humane ethics, oral historians create archives that serve both public scholarship and the interest of those whose voice they preserve. I hope you all enjoyed the class. Thank you so much.